Judiciary Committee will please come to order, quorum being present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the yeas and nays are ordered. Pursuant to notice, I now call up the committee report for a resolution recommending that the House of Representatives find William Barr, Attorney General, U.S. Department of Justice, in contempt for refusal to comply with a subpoena duly issued by the Committee on the Judiciary for purposes of markup, and move that the committee reported favorably to the House.
Mr. Chairman, I demand the question of consideration.
Before we read the bill?
I believe this is when the motion lies.
The question of consideration is not debatable. The question is, shall the committee consider the committee report? All those in favor say aye. Aye. Opposed? No. The ayes have it.
Roll call, please.
Roll call is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Richmond votes yes. Mr. Jeffries? Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Liu votes aye. Mr. Raskin? Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Ms. Demings votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Collins votes no. Mr. Sensenbrenner? Mr. Sensenbrenner votes no. Mr. Shabbat? Mr. Gomert? Mr. Gomert votes no. Mr. Jordan? Mr. Jordan votes no. Mr. Buck? Mr. Ratcliffe? Mr. Ratcliffe votes no. Ms. Roby? Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Reschenthaler votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Stubbe? Mr. Gates, you are not recorded. Mr. Gates votes no.
I don't need to. Gentleman from Georgia?
Yes.
Mr. Johnson of Georgia votes yes.
Gentlelady from Florida? Oh. Is there any member of the committee who wishes to vote who hasn't voted? Clerk will report.
Mr. Chairman, there are 22 ayes and 12 noes.
The motion for consideration is adopted. The clerk will report the committee report.
Resolution recommending that the House of Representatives find William P. Barr, Attorney General, U.S. Department of Justice, in contempt of Congress for refusal to comply with a subpoena duly issued by the Committee on the Judiciary.
Without objection, the committee report is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today, we consider a report recommending that the House of Representatives hold Attorney General William Barr in contempt of Congress for defying a valid subpoena issued by this committee. This is not a step we take lightly. It is the culmination of nearly 3 months of requests, discussions, and negotiations with the Department of Justice for the complete unredacted report by Special Counsel Mueller into Russian interference in the 2016 election, along with the underlying evidence. I appreciate the fact that the Department responded to the offer we made to them last week and met with us yesterday in a last-minute effort to reach an accommodation. We heard the Department out, we responded to them in good faith, and after all was said and done, we unfortunately were still unable to reach agreement, and we proceeded with our markup today. As I have said before, we remain ready and willing to consider any reasonable offer made by the Department even after today's vote. But if a letter I received late last night from the Department is any indication, I am concerned that the Department is heading in the wrong direction. In response to our latest good faith offer, the Department abruptly announced that if we move forward today, it would ask President Trump to invoke what it refers to as a protective assertion of executive privilege on all of the materials subject to our subpoena. Just minutes ago, it took that dramatic step. Besides misapplying the doctrine of executive privilege, since the White House waived these privileges long ago, and the Department seemed open to sharing these materials with us just yesterday, this decision represents a clear escalation in the Trump administration's blanket defiance of Congress' constitutionally mandated duties. I hope that the Department will think better of this last-minute outburst and return to negotiations. As a co-equal branch of government, we must have access to the materials that we need to fulfill our constitutional responsibilities in a manner consistent with past precedent. This is information we are legally entitled to receive, and we are constitutionally obligated to review. And I would remind the members that the Mueller report is no ordinary run-of-the-mill document. It details significant misconduct involving the President, including his campaign's willingness and eagerness to accept help from a hostile foreign government, numerous misstatements, if not outright lies, concerning those acts, and 11 separate incidents of obstructive behavior by the President that more than 700 former prosecutors have told us warrant criminal indictment. If Congress is not entitled to the full unredacted Mueller report, one must wonder what document we would be entitled to. Our exhaustive negotiations with the Department of Justice have unfortunately left us back where we began, with unprecedented obstruction by an administration that has now announced its intention to block all attempts at congressional oversight of the executive branch. It is our constitutional duty to respond. Let me be clear. The information we are requesting is entirely within our legal rights to receive and is no different from what has been provided to Congress on numerous occasions going back nearly a century. But we do not need to go back that far to find the precedent. As recently as the last Congress, under Republican control, the Department produced more than 880,000 pages of sensitive investigative materials pertaining to its investigation of Hillary Clinton, as well as voluminous other material relating to the Russia investigation and other ongoing investigations. That production included highly classified material, notes from FBI interviews, internal text messages, and law enforcement memoranda. With respect to grand jury information, in past cases involving allegations of presidential misconduct or misconduct by other high-ranking public officials, the Department of Justice, as a matter of course, has sought the permission of a court to release relevant information to Congress, if not to the public. Notably, this includes several cases that were not impeachment inquiries, including the investigation into former Agriculture Secretary Mike Espy and the Iran-Contra investigations, as well as other investigations that were not governed by the independent counsel law. But no matter the fact that the law and history clearly support the release to Congress of this kind of information, the Trump administration has taken obstruction of Congress to new heights. Unfortunately, the Attorney General has been all too willing to support the President in this endeavor. I would also like to respond to two of the concerns often raised by my good friend, the ranking member. He asks, how can the committee hold the Attorney General in contempt for merely complying with the laws on the books? And how can we hold him in contempt when I have refused an offer to allow me to see certain redacted portions of the report? The answers are simple. First, we issued a valid subpoena for the full report and all of the underlying evidence. The Department has come nowhere close to satisfying its obligations under that subpoena. The Department has never cited a legal basis for withholding the underlying evidence, including last night's threat to invoke executive privilege, which was utterly without credibility, merit, or legal or factual basis, as is, of course, the assertion of, or the statement that they will assert executive privilege by the White House this morning. To the extent that we have asked for access to grand jury information, which is protected by federal law, all we have ever asked is that the Department join us in petitioning the court to determine if it is proper for us to have access to this material. The Department, as I said, has done this on many occasions in the past. We asked for a commitment to join us in that effort again last night, as it has done in many previous cases, and the Department refused. Second, with respect to the offer to lift some of the redactions for me and a handful of my colleagues, the Department has placed unacceptable limitations on access to that information. Their offer would block the members of this committee from reading those sections of the report for themselves. It would require me to leave my notes behind at the Department of Justice. It would prevent me from speaking with my colleagues, with other members of the committee, about what I might see. What good is it? Of what use can this committee make of information that I have but can't discuss with any other member of the committee? I have consistently stated that if we are to do our jobs as members of the House Judiciary Committee, all of the members require meaningful access to the report and the underlying documents. We need to be able to confer with each other about what we have seen. We need to be able to take official action on what we have seen, if warranted. And if necessary, we need to be able to inform a court of law of what we have learned, even if perhaps under seal. If we can find an accommodation that satisfies those basic principles, I would be happy to continue negotiating with the Department of Justice. But now, by invoking executive privilege on all of the material subject to our subpoena, that process has come to a screeching halt. The administration has announced, loud and clear, that it does not recognize Congress as a co-equal branch of government with independent constitutional oversight authority, and it will continue to wage its campaign of obstruction. When the administration says it will oppose all subpoenas, presumably regardless of its merits, it is saying that it does not recognize Congress having a constitutional oversight authority over the executive branch. And to those who consider the matter case closed, in the words of some of our leaders, and who urge us to simply move on, I would say that to do so is to announce loud and clear that such a course of action has the effect of aiding and abetting in the administration's campaign of total, blanket, and unprecedented obstruction. The Trump administration and its enablers may brazenly try to cover up the misdeeds uncovered by the Special Counsel. But in this committee, we will represent the American people and ensure the truth is known. I urge my colleagues to think about how the Department's latest position and their insistence on ignoring our subpoena affects our committee over time. Our fight is not just about the Mueller report, although we must have access to the Mueller report. Our fight is about defending the rights of Congress as an independent branch to hold the president, any president, accountable. Every day we learn of new efforts by this administration to stonewall Congress, and through Congress to stonewall the American people. The Ways and Means Committee has been denied the president's tax returns when the law states clearly that they are entitled to them upon request. The chairman of the Oversight and Reform Committee has been sued in his personal capacity to prevent him from acquiring certain financial records from the Trump Organization. The president has stated that his administration will oppose all subpoenas, and in fact, virtually all document requests are going unsatisfied. Witnesses are refusing to show up at hearings. This is unprecedented. If allowed to go unchecked, this obstruction means the end of congressional oversight. As a co-equal branch of government, we should not and cannot allow this to continue, or we will not be a co-equal branch of government. I urge my colleagues, whether or not you care to see the full Mueller report, and we should all want to see the complete report, to stand up for the institution we are proud to serve. I expect that we will have a full debate today on the measure before us. I hope that at the end of it, we will do what is right. No person, and certainly not the top law enforcement officer in the country, can be permitted to flout the will of Congress and to defy a valid subpoena. No person, not the Attorney General, not the President, can be permitted to be above the law. That is what is at stake today. I urge all of my colleagues to support this report. I now recognize the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, and to the folks watching here, this slog continues. Last week, I urged you and my fellow members of the Judiciary Committee Democrats to respect the histories and traditions of this committee and conduct its business accordingly. We still have a crisis on our southern border. China is stealing our intellectual property, yet here we are, wasting another valuable week of the legislating calendar against the majority's war against the administration. Today, we are meeting to consider a resolution to hold Attorney General Bill Barr in contempt of Congress. So let's take just a few moments and go through this. What is the justification for holding Attorney General Barr in contempt of Congress? Perhaps that he failed to abide by the Special Counsel regulations? No, he went above and beyond what the regulations required by transmitting the full report to Congress with limited redactions. Could it be that the Attorney General failed to accommodate the Chairman's demands for information? No. He offered to let the Chairman and 5 other Democrat leaders review the less redacted report at the Department of Justice, including a 99.9% unredacted volume on obstruction. In an odd move for anyone demanding access to information, the Chairman and the other elected Democrats given access have declined to view that report. The Attorney General also volunteered to testify before this committee about the report's conclusions and his role in sharing the report. And as we all witnessed, the Democratic gamesmanship forced the Attorney General to forego the scheduled hearing last week. On Monday, the Justice Department offered to meet to discuss accommodations. Yesterday, they made a reasonable offer to avert this spectacle, and once again, they were rebuffed and the Chairman declined. Perhaps then the Democrats believe that there has been an unreasonable delay in the Justice Department's response to their subpoena. No, that's not true either. In fact, the Chairman is moving to this contempt resolution at lightning speed. It has been less than 20 days since the Chairman Nadler subpoenaed documents from the Justice Department. When the Oversight Committee held Attorney General Eric Holder in contempt, more than 250 days had passed between the subpoena and the committee's vote to hold him in contempt. More than 450 days passed between the committee's initial request to the Justice Department and the committee's contempt vote. Judiciary Democrats are moving more than 10 times faster than Oversight did with Holder. They have moved from request to contempt vote in only 43 days. And yet the Justice Department is still at the negotiating table waiting for the Democrats to arrive in good faith. Why this rush? Without any valid legislative or administrative reason, we can only assume the Democrats that are led by the Chairman have resolved to sully the Bill Barr's good name and reputation to accomplish 2 goals. First, Democrats are angry the Special Counsel's report did not produce the material or collusions they expected to pave their path to impeaching the President. I feel compelled to remind everyone the report found, despite offers to do so, no one from the Trump campaign knowingly conspired with the Russian government. And you can't help but notice the phrase Russian collusion has vanished from the Democratic talking points and left a void in the narrative. Since the Special Counsel did not make a prosecutorial determination on obstruction, which was his job, the Attorney General and the Deputy Attorney General did so according to their mandates as law enforcement officials while giving no credence to the Office of Legal Counsel's opinion regarding that of sitting presidents. As a result, they're angry. They're angry our nation's chief law enforcement officer and his deputy had the audacity to decide the evidence didn't support charges for obstruction and investigation into something the President didn't do. Second, Democrats are afraid of what the Attorney General will find when he completes his ongoing review of FISA abuses at the Justice Department, including how the Russia investigation began. Multiple news reports have suggested those conclusions could be explosive, could end careers, and could even lead to criminal prosecution. Rather than face that, the Democrats have resolved to neutralize Bill Barr by attacking him and the office and his integrity and his career. This is the first step. What a cynical, mean-spirited, counterproductive, irresponsible step it is. Meanwhile, our economy is surging, unemployment among several minority groups is at historic low. A recent Washington Post poll shows cratering support for impeachment, but Democrats have no plans, no purpose, and no viable legislative agenda beyond attacking this administration. The House is more than 4 months into a Democratic majority. How many bills passed by this committee have been signed into law? Mr. Chairman, I implore you to see reason. I ask that you recognize the craven and insincere politics that seem to be yielding no dividends for the American people. We've talked on multiple occasions and proved at last week's pharmaceutical markup that I stand ready to work with you to promote solutions. I will not, though, become a bystander as we assail the Attorney General and this committee. Our democracy deserves better. Finally, Mr. Chairman, I'd like to quote a fellow member of Congress. As a member of Congress, I treat assertions of executive privilege very seriously. I believe they should be used only sparingly. In this case, it seems clear the administration was forced into a position by the committee's insistence on pushing forward with contempt. Despite the Attorney General's good faith offer, Mr. Chairman, it did not have to be this way. We could have postponed today's vote and accepted the Attorney General's offer. Instead, by not honoring the Constitution's charge to seek accommodations when possible, the prestige of this committee has been diminished. As a result, that should concern us all. I quote Elijah Cummings. In that case, of course, the committee did seek accommodations. In this case, this committee did not. And in just a difference of opinion between me and the chairman, there has been no escalation of this except on the side of the majority. You have to have both sides at the table for accommodations. That's the way this process works. That is what I've just laid out, 10 times faster than even Eric Holder. And when we get into the other issues that have been discussed here, and again, how we deal with this is going forward with what will be the precedent for the future and will be the precedent for what we have. With that, I yield back.
Thank you, Mr. Collins. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to the committee report for the resolution recommending that the House of Representatives find William P. Barr, Attorney General.
The amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute contains a technical change to page 2 of the committee report. It simply changes the reference on that page to Judiciary Committee to the Committee on the Judiciary. With this modest change, I urge the committee to support the amendment. I now recognize the ranking member of the full committee, Mr. Collins, for any comments he may have on the amendment.
On the amendment itself, I thank you, Mr. Chairman. I don't have any as far as the amendment nature substitute. I will make one comment that was made in your previous opening statement. The chairman of now the Oversight Committee was not sued in his personal capacity. He was served in his official capacity in that committee. And just a clarification for the record there as we go forward. With that, I have no objection to the ANS.
Are there any amendments to the amendment in the nature of a substitute? Who seeks recognition?
Mr. Chairman.
For what purpose does the gentleman from Ohio seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Our Democratic colleagues seem to be on a mission. They're determined to destroy Attorney General Barr, or at least discredit him in the eyes of the American people. The Attorney General agreed to appear before this committee last week and was ready to answer any and all questions about the Mueller report. However, Mr. Chairman, you and your Democratic colleagues on this committee decided that instead of just answering questions from members of the committee, well, we unprecedentedly were also going to require him to be grilled by a bunch of partisan staff lawyers. Of course, the Attorney General wisely said, no way, and now you're determined to find him in contempt. In my view, as somebody who served on this committee for 23 years, I think it's disgraceful. Last week, when the Attorney General refused to show up for this committee's kangaroo court, the majority set up an empty chair, ate chicken, and pretty much made a mockery of this committee, a committee that was once led by the likes of Daniel Webster. It's worth noting that Attorney General did appear before the Senate Judiciary Committee the day before he was scheduled to come here, where the unreasonable demand that he be queried by staff attorneys was not made. Senators did the questioning themselves, as is normal, and the same should have been the case here instead of Chickengate. And let's be clear, it wasn't a day at the beach in the Senate for the Attorney General. The senators themselves were perfectly capable of being rude, abusive, and arrogant all by themselves. They didn't need their staff to do it for them. So why this passion to tear into William Barr, an Attorney General, at least up to this point in his career, considered a person of upstanding, in fact, outstanding character. Well, first, our Democratic colleagues are apparently really ticked off about the Mueller report, that it found that the whole Russian collusion thing was a big fat zero. And even though the obstruction of justice allegation wasn't as clear-cut, Special Counsel Mueller found that there was insufficient evidence to pursue a charge against President Trump or against anyone else for that matter. Excuse me, William Barr did that. So Democrats are mad about that, but what I think is even more important is that our Democratic colleagues are afraid. They're afraid that unlike former Attorney General Sessions, who had recused himself from anything related to the Mueller investigation, Bill Barr is going to dig into the origins of the bogus Russian collusion allegation itself. The Clinton campaign funding of the Steele dossier was the actual collusion between the Russians and the political campaign. Is that something that's finally going to be looked into? That was the real political collusion with the Russians. The FBI's involvement in trying to tip a presidential election in favor of one candidate over another, the whole Peter Strzok, Lisa Page, all of that. The idea that Trump may have been right, that his campaign really was spied on by elements of the Obama administration, despite the fact that this accusation was met with such derision by most of the mainstream press at the time. The bottom line is many Democrats on this committee, and in fact many Democrats in both the House and the Senate, apparently believe that finding out the truth in these matters may not be helpful to them in the upcoming election cycle. And the best way to undermine the results of the investigation, the true investigation, which is really about to happen, might just be to destroy the credibility of the guy who's doing the investigation, the Attorney General, William Barr. And let's begin that process, apparently according to the folks on the other side of the aisle, and the chairman included, by finding him in contempt. That's the way we can really discredit him. At least that's the way I see it. And I yield back.
Before I proceed to the next statement, let me just clarify a point of apparent confusion. We are not proposing to hold the Attorney General in contempt for not showing up last week. He didn't show up last week, but that has nothing to do with this motion for contempt. We are proposing to hold him in contempt for ignoring or for not satisfying the subpoena for the production of documents, namely the unredacted Mueller report and underlying evidence. Who seeks recognition?
Mr. Chairman.
Gentleman from, the gentlelady from Texas. For what purpose does the gentlelady from Texas seek recognition?
Like the last word.
Gentlelady is recognized.
I'm pausing for a moment because I do think this is a moment in history. And I appreciate my good friends on the other side of the aisle. But having received a letter both from a copy of the letter to the President of the United States by General Barr and a letter from the Department of Justice indicating after their purposeful collapse of the negotiations, well-intentioned by the staff and House Judiciary Committee, I can only conclude that the President now seeks to take a wrecking ball through the Constitution of the United States of America. For the first time in the history of the United States, a president is now exerting executive privilege over every aspect of life that the American people desire to have information. Whether or not their Affordable Care Act is dissolving the pre-existing condition, whether or not children are being separated from their parents, whether or not the environment is being destroyed. Anything that the Congress wants to do on behalf of the American people is now being alleged to be under the jurisdiction of privilege. Then, of course, we have to surmise that this is an absolute lawless behavior by this administration. The Attorney General actions are contemptuous and insulting to Congress, but we're simply the tools it is to the American people. To broaden the executive privilege and ignore the constant accommodations that Chairman Nadler has made and our staff in working to work out three simple points. Give us all of the documents, unredacted Mueller report for the American people to see. work with us on grand jury materials, not to undermine, if you will, any ongoing investigations, and work with us to list the documents by priority. That is very simple. To recount facts of yesteryear does not even speak to the fact of the hundreds of investigations that my good friends, when President Trump and the Republican House and Senate existed, they never ceased. They never ceased going after Secretary Clinton, getting 880,000 documents in a Benghazi hearing that went forever and ever and never found anything. I happen to believe 700 former prosecutors who indicated that the Mueller report describes several acts that satisfy all elements for an obstruction charge conduct. Congressman Jackson Lee didn't say this. Chairman Nadler did not say this precise statement as a former federal prosecutor. It's 700 who've indicated that the actions of this president warrant an obstruction charge. In addition, we have a right to understand the underlying reasons regarding the collusion report. But the very fact that the collusion part of the Mueller report recounts the constant interaction of Trump operatives with Russian adversaries, the American people should be wary, and they should ask us why. And we should write legislation, as I've introduced H.R. 2353, that says if you interact with a Russian operative or foreign adversary as a campaign committee or candidate, you must report it to the FBI. And so this is part of our legislative work. And I would argue the case that our friends on the other side of the aisle should not be noted in history of standing at the door of justice in this room and putting up a stop sign that we cannot pursue the truth on behalf of the American people. We have gone over and over and over again that there are allegations of obstruction of justice that need to be heard in front of this committee. I say this, Mr. Mueller, a former Marine, a man of integrity, I will say to him in the open proceeding, we welcome you to come and explain your position on how disturbed you were that the Attorney General characterized your report as an exoneration of this administration. Secondarily, I want to say to Mr. McGahn, you are a private citizen. You have every right to present yourself to this body. And also that the conduct of President Trump described in Special Counsel Mueller's report would, in the case of any other person, if not having the Office of Legal Counsel policy against indicting a sitting president, would result in felony charges. There are people incarcerated right now because of lesser charges. I don't want to target the president, Mr. Chairman. I simply want to find the truth for the American people, and that's why we're here today to vote on this citation for lacking of producing of documents. I yield back.
Chairman. Mr. Chairman. Mr. Chairman.
Gentleman from Wisconsin, for what purposes is the gentleman seek
Move to
recognition?
strike the last word.
Gentleman is recognized.
Mr. Chairman, I think we ought to step back from the political rhetoric and ask exactly what this contempt citation deals with. And I'm going to try to use my time to do that. First and foremost, and most concerning to every American, or at least it should be, is the fact that they want an unredacted report that includes information on grand jury testimony. The committee, by making this insistence and issuing this subpoena, is telling the Attorney General of the United States to commit a crime, because it's a crime for anybody to disclose grand jury material to anybody else. That includes the Attorney General, it includes the prosecutors in the Justice Department, it includes the witnesses who have been subpoenaed and have testified before the grand jury. It means everybody. And if the grand jury system is to work, and remember, witnesses can't even bring their attorneys into a grand jury, then the secrecy is going to have to be maintained. Now, all of us know that it's really impossible for the people who work on this Capitol Hill to keep a secret. If there is an unredacted version, completely unredacted version, including the grand jury testimony, which is unredacted. It'll be on the front page of every newspaper in the country within 48 hours and talked about incessantly on the cable news shows, whether you watch Fox News or whether you watch MSNBC. Now, I think it is absolutely shocking that the majority of this committee is going to ask the chief law enforcement officer of the United States to commit a crime. Shocking. And there are no exceptions to what is to be disclosed in this unredacted version. That includes the grand jury testimony. And by citing the Attorney General of the United States for contempt of Congress, for saying, I'm standing up for the law, I am not going to break the law by complying with that part of your subpoena, shows an overreach on the part of the majority. If we are to be a government of laws and not of men or of people, then we have to obey the law on this end of Pennsylvania Avenue as well as on the other end of Pennsylvania Avenue. And we are not doing that. Now, what else has been redacted? There's been redactions relative to ongoing investigations. Now, do we want to let the people that the Justice Department is investigating know all about the ongoing investigations? I don't think the public interest is served by that. Whether somebody is guilty or not should be determined by the jury in a trial. That's what the American system is, and that's what a lot of the Bill of Rights protects. You also have a protection against people who are peripherally involved in that. They were just on the edges of this. They were interviewed, and nothing came of the interview because they didn't have any evidence on what was being investigated. But there's a character assassination squad running around this town that even if you were on the periphery and went and voluntarily talked to the FBI or Mr. Mueller's team, you know, you're going to end up having your good name and your reputation smeared even though you didn't do anything. So this is definitely an overreach. Those redactions, ended up being justified redactions, and I can understand the reluctance on the part of the Attorney General or anybody else that watches the way this institution and the people who work here operate, that anything that is supposed to not get out in the public realm will get out in the public realm with a leak. And if this place weren't as leaky as a sieve, I would not be opposed to what the chairman is doing because I've stood up for oversight during my entire career in this body. But it is leaky as a sieve. And I think what we're doing here is forcing the Attorney General to break the law, to place in jeopardy innocent people, you know, who are not involved in any of the things that Mr. Mueller ended up investigating, and shaming ourselves in the process. My time is up.
For what purpose does the gentleman from Tennessee seek recognition?
Strike the last word.
The gentleman is recognized.
Thank you, Mr. Chair. The Attorney General has been contemptuous of this committee and of the Congress. He was contemptuous last week when he didn't come, when he couldn't dictate the terms of the hearing. He's contemptuous this week when he will not bring forth papers. The chairman has tried to reach an accommodation with the Justice Department. All cases in the past when such issues have been raised about grand jury testimony, the Attorney General has gone with the majority party, the chairman, to the district court and asked that that information be released to the committee for its purposes. This Attorney General has not done that. If he would have done that and tried to make a reasonable accommodation to join with us in going to Judge Howell, we might not be in this situation. But there's been nothing reasonable from this Attorney General. Mr. Sensenbrenner talks about people on the periphery. We don't know who those people were, but we know that Bill Barr decided which testimony would be redacted because people were on the periphery and to protect their reputations. This is the same person who gave a 3.5-page summary of the Mueller report
that did not, according to Special Counsel Mueller, who knew it better than anyone else, reflect the character and the spirit of the report. And he knew Mr. Mueller objected to it for not being an accurate representation of his work, and yet he did it. And when asked about it by Mr. Christ in committee, he had no idea that Mr. Mueller or anybody in the Mueller Special Counsel investigation would have objected. That's not true. He lied when Mr. Christ asked him that question. That's beyond contempt. That's a lie. So we're depending on Mr. Barr's determining who was on the periphery and what their reputations would suffer. We're talking about the opportunity for Congress to do its proper oversight as described in Article 1 of the Constitution, which is being trampled upon. The Trump administration refuses to respond to any subpoenas, destroying Article 1 and Congress's prerogatives. Now, we had a question, I think it was maybe the ranking member said we should be doing legislation, and how many signatures, how many bills have been signed into law by this committee? Well, ask Mitch McConnell, who has declared that the Senate is a graveyard for all legislation that comes from the House. We have passed outstanding legislation out of this committee. It's gone to the graveyard, where Mitch McConnell, who first kills Supreme Court nominees of the last President of the United States in his 1 year before, and voids and frustrates the constitutional prerogative of the President to nominate members to the Supreme Court, but now frustrates the other House by not having hearings whatsoever. Somebody said we're afraid. Yes, we're afraid. We're afraid of the loss of the rule of law. We're afraid of the loss of the power of Congress to be an independent and co-equal branch of government. And we face that today if we don't stand up. And somebody else said that Russia, there are no connections and nothing with Russian collusion. Well, the Mueller report said there was sweeping and systematic efforts by the Russians to influence our election, and they were done so to help Trump. And the Mueller report showed lots of connections between the Trump campaign and Russia, lots of contacts, and didn't show that he had all of the elements to prove beyond a reasonable doubt that they conspired together. There's a big difference between not having connections and having guilt beyond a reasonable doubt. Then Mr. Trump gets on the telephone with Mr. Putin and has a 90-minute conversation or something like that, where he can see on a phone call that he smiled at him and he gets flattered, and never broaches the subject of Russian interference in our next election or Russian interference whatsoever. That was one of the prime parts of the Mueller report, that the Russians interfered, and that our intelligence officials had confirmed and told us, and that our FBI has told us, and that we know they did it in 2018, and they're going to do it more in 2020. But our president did not even mention it to Mr. Putin. That is scary. We are afraid of interference in the 2020 elections, and we need to be. And we need to be because we've got a man who has been suggested might be financially dependent on the Russians. Why would he be financially dependent on the Russians? Well, we now know he lost over $1 billion in a decade in the 80s and 90s. He was broke. No bank would loan him a penny. He was broke. And if it weren't for him being president, he'd be in prison with Michael Cohen today as individual one, and he obstructed justice as the Mueller report says it so. We are in danger. We need to respond, and we need to act for the people of the United States of America. I yield back the balance of my time.
For what purpose does the gentleman from Texas seek recognition?
Ask to strike the last word.
Gentleman is recognized.
Thank you. I'm really here in mourning for a once great Judiciary Committee. I know my first term, 05 and 06, I saw our current chairman as a champion for privacy rights, for civil rights, for Fourth Amendment rights, Fifth Amendment rights, and something dramatically has changed over the years. There was concern back then about too much power through the FISA courts, through the Patriot Act, and we shared a number of those concerns. And now this committee majority is on the wrong side of a very important historic time. We've never had the intelligence community, the FBI, people at the top of the DOJ abusing their powers to create a case against a president where there was none, where assets were actually used to try to set up members of the Trump campaign when there was no case, to try to create a case. We ought to be all over that. We ought to be demanding answers from the FISA judge or judges who were either A, content to have fraud committed against their courts, or were complicit. Maybe it was Peter Strzok's buddy that he bragged about in his text that was going to be the FISA judge that signed warrants where there was no probable cause of anything. This was an attempted coup, and history is bringing that into focus more and more clearly. And what does this committee do about the abuses, the attempted coup? It comes in and decides we're going to go after the Attorney General who's trying to clean up the mess. Christopher Wray sure hasn't. Instead of asking from the intel community, let us see the 100% certain proof you have that Hillary Clinton's personal server was hacked by China. No, he covers it up, says we still hadn't seen it. Well, they hadn't asked to see it. There is a disaster that has occurred in our justice system, and this committee has oversight responsibilities, and we are abusing those. This motion for contempt is not being done in good faith. I'm not going to call anybody on this committee the names that my colleague from Tennessee just did in violation of our rules of decorum. But the truth is, we know that this committee majority is not acting in good faith. How? Because they're moving for contempt for an attorney general failing to turn over material that this majority, at least some, maybe it's just the staff, but some people know that you can't hold someone in contempt. You can vote to do that, but you can't be in contempt for failing to produce things that are illegal for you to produce. How do we know? Somebody over there knows that this is wrong. Is because there was an offer. Look, Attorney General Barr, if you'll join us in going to court and getting a court order so that we can get the grand jury proceedings and evidence, then we will disregard the contempt. Well, that's evidence of a state of mind by the majority that at least somebody over there knows you cannot be in contempt for failing to produce what would be illegal to produce without a court order. You're on the wrong side of history. And there is no joy here in seeing the abuses. I hope and pray literally for the day when we can join forces and quit trying to push this idea of an attempted coup and uncover the abuses that have truly gone on. My time's expired. The committee's has too.
Thank the gentlelady. The gentlelady from Pennsylvania. For what purpose does the gentlelady seek recognition?
I move to strike the last word.
Gentlelady's recognized.
Thank you. You know, it's easy to lose focus when the White House and our colleagues across the aisle engage in whataboutism or what is the distraction of the day or even misleading legal arguments. Nobody's asking the Attorney General to disobey the law. We're asking the Attorney General to obey the law and produce the Mueller report and the supporting documentation, the underlying evidence that we've been requesting for a couple months now and that the American people have been awaiting for 2 years. Why is this important? Well, if you think there's no collusion and no obstruction, you haven't read the Mueller report. I admit it's not an easy read, but it clearly states that there was coordination, there's evidence of coordination, it clearly states there are multiple instances of obstruction of justice, and it clearly refers that over to Congress to deal with. Over 700 federal prosecutors have now reviewed that evidence, just the redacted evidence, not even the underlying evidence, and stated unequivocally that it shows multiple instances that would be felonies if it was anyone other than a sitting president. And that's the reason why Mueller didn't charge. He says in his report, it was a sitting president under the rules I'm operating under. I couldn't file charges. That's why it's Congress's job to do something about it. And that's why we're staying focused on our job. I'm not joyful about this. I'm not afraid of where it takes us. What I am is profoundly saddened that we're in a position where we have an administration that is stonewalling, yes, even acting in contempt of not just Congress, not just the rule of law, but the American people. And with that, I yield back.
Mr. Chairman.
Who seeks recognition?
Mr. Chairman.
For what purpose is the gentleman?
Move strike the last word.
Gentleman is recognized.
Bill Barr is following the law, and what's his reward? Democrats are going to hold him in contempt. I don't think today's actually about getting information. I don't think it's about getting the unredacted Mueller report. I don't think last week's hearing was actually about having staff question the Attorney General. I think it's, as my colleague said earlier, I think it's all about trying to destroy Bill Barr because Democrats are nervous he's going to get to the bottom of everything. He's going to find out how and why this investigation started in the first place. Never forget what Bill Barr said a few weeks ago, 3.5 weeks ago when he testified in front of the Senate Finance Committee. Said a lot of important things, but he said four very interesting things. First, he said there was a failure of leadership at the upper echelon, term he used, upper echelon of the FBI. We all know that's the case. Director Comey's been fired. Deputy Director McCabe fired, lied 3 times under oath, according to the Inspector General. FBI counsel Jim Baker demoted and left, currently under investigation by the Justice Department. Lisa Page demoted and left. Peter Strzok, deputy head of counterintelligence, demoted and fired. Peter Strzok, the guy who ran the Clinton investigation and the Russian investigation. There was certainly a failure of leadership at the upper echelon of the FBI. Second thing the Attorney General said 3.5 weeks ago in front of the Senate Finance Committee. Spying did occur. Said it twice. Yes, spying did occur. Third, he said, there's a basis for my concern about the spying that took place. And maybe the most interesting thing, 2 terms he used that frankly I find frightening. He said there was, in his judgment, he thinks there may have been unauthorized surveillance and political surveillance. Scary terms. We got to go back to January 3rd, 2017. Senator Schumer on the Rachel Maddow show talking about then President-elect Trump says this: if you take on the intelligence community, they have 6 ways from Sunday at getting back at you. Now, I don't know if the FBI went after President Trump in 6 ways, but I sure know they went after him in 2 ways. And the first one is the now famous dossier. On October 21st, 2016, the FBI used one party's opposition research document as the basis to go to a secret court to get a warrant to spy on the other party's campaign. That happened. Democrat National Committee, the Clinton campaign, paid Perkins Coie law firm, who hired Fusion GPS, who then hired a foreigner, Christopher Steele, who did what? Talked to Russians and put together this salacious, unverified document that became the basis to get a warrant to spy on the Trump campaign. They did it. And when they went to the court, they didn't tell them important things like who paid for it. They didn't tell them that Christopher Steele had already told the FBI and the Justice Department that he was, quote, desperate to stop Trump. And they didn't tell the court that Christopher Steele had been fired by the FBI because he's out talking to the press. They did that. And second, just last Thursday, New York Times story, FBI sent investigator posing as an assistant to meet with the Trump aide in 2016. FBI sent someone in, pretending to be somebody else, to talk with George Papadopoulos, who was with the Trump campaign. You know what they call that? You know what they call that? It's called spying. They did it. They did it. They did it twice, and who knows how much more. And what I know is Bill Barr has said he's going to get to the bottom of it. And think about the term he used again. This is important. political surveillance
Would the
in the
gentleman
United
have a quick
States of
question?
America. I will not yield. Think about that term. He's going to get to he said he's going to put a team together, going to investigate all this. This is critical. And never forget the guy who ran this investigation, Peter Strzok, ran the Clinton investigation and then launched and ran the Trump-Russia investigation. Never forget what he said. Trump should lose $100 million to zero. We need an insurance policy. Told Lisa Page, don't worry, Lisa, we'll stop Trump. This is what Bill Barr wants to investigate. And as my colleagues have said, this is the House Judiciary Committee, with the history this committee has in protecting fundamental liberties and protecting the Constitution. Last week, there was another important document Emmett Flood sent to the Attorney General. I just want to read a couple sentences. Under our system of government, unelected executive branch officers and intelligence agency personnel are supposed to answer to the person elected by the people, the president, and not the other way around. This is not a Democrat or Republican issue. It's a matter of having a government responsible to the people, to we the people. In the partisan commotion surrounding the Mueller report, it would be well to remember that what can be done to a president can be done to any of us. And this committee is supposed to look out for that fundamental fact more than anything else. And we are not doing that today. I yield back.
I would simply observe that, to his credit, Mr. Jordan has been second to none in asking for access to the materials we're asking for the, and I simply ask him, does he still think is he still supporting his own request for that the committee and the Congress be given access to the entire report and the underlying information?
Consistent with the law, and I would ask the chairman. My understanding is Mr. Mueller's going to be here next week. Why are we doing it? You're going to get to ask the guy who wrote the whole darn document. We're all going to get asked him questions. Why don't you hold off on this contempt until at least the guy who wrote the thing spent 22 months and $35 million with a whole bunch of Democrat lawyers putting it together? Why don't you wait and ask him next week before we do this contempt resolution?
I'll answer, well, essentially because it would be useful to read the material before we have him in front of us. In any event, the gentleman, for what purpose is the gentleman from Georgia seek recognition?
I move to strike the last word.
Gentleman's recognized.
Thank you, Mr. Chairman. For most people in America, the end of the Mueller investigation did not equal the end of the story. The American people want to see and hear the full story, and they deserve to do so. And in fact, Investigator Mueller intended for the American people and for Congress to have the full story. He did so in his unredacted summaries for both the obstruction and the Russian influence investigations. And what happened when he issued his report, William Barr did something unprecedented. He put together his own 4-page summary, which was misleading, which failed to properly and adequately and accurately characterize the conclusions of the Mueller investigators. He did that. He waited for about a month while that narrative marinated among the American people, and it was reduced down to 4 words: no collusion, no obstruction. And they ran with that for a month before finally the redacted report was issued by Bob Barr. But before he issued the report, 2 hours before he issued the report, he had a press conference to again summarize the Mueller report's findings. And again, he failed to accurately portray and represent those results. And so finally, the redacted report was revealed to Congress and to the American people, and the American people and Congress saw clearly that Bob Barr was a part of the president's ongoing obstruction. He obstructed the Russia investigation. He obstructed all matters that Mueller was investigating, and now he's trying to obstruct Congress and the American people in finding out what's in that report. And what is very troublesome is my colleagues on the other side of the aisle are aiding and abetting them in their cover-up. So still, the full results of the Mueller investigation are not known. Congress, the House of Representatives, the Judiciary Committee has demanded an unredacted report that should be available to all of the members of at least the House Judiciary Committee. The Attorney General Barr has stonewalled, as he has been instructed to do by the President, and he's a willing participant in this, mind you. They are obstructing the American people's ability to understand what happened. They're hiding behind Rule 6E of the Federal Rules of Evidence, which make grand jury proceedings secret. But as my colleague from Wisconsin should know, there are 5 exceptions listed in 6E that enable the disclosure of grand jury information. He knows that. There's no reason for the American people to be misled about that. And William Barr knows that also, and he also knows that previous attorney generals in his situation have gone to Congress, have gone to the courts with the House of Representatives and obtained grand jury materials when necessary. And so this is all part of a cover-up. And it is up to this committee to ensure that we get that report, because we have lawful responsibilities, constitutional responsibilities to engage in, one of which is possibly impeachment. How can we impeach without getting the documents? So we must get this document. The American people expect us to do it. Once we get it, our hearings can continue and lead to whatever they may lead to, including impeachment. And so I ask my colleagues on the other side to stop obfuscating and start working with us to carry out your constitutional responsibilities. And with that, I yield back.
For what purpose does the gentleman from Florida seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Glad to see that the microphone's working this week. My good friend from Georgia just asked the operative question: how can we impeach if we don't get the documents? How can we impeach if we don't get the documents? Ladies and gentlemen, this hearing is not about the Attorney General. It's not about the Mueller report, 92% of which everyone in America has had the opportunity to read. It's not about the fact that even the portions that the American people haven't been able to read, the chairman's been able to go read had he chosen. This is all about impeaching the president. Now, why don't they just say it? Why don't they just jump to the impeachment proceedings like their liberal media overlords are telling them to do? Well, the reason is that the American people don't support impeachment. And it's easy to understand why. They actually went and elected Donald Trump president of the United States. And I don't think people are going to support impeaching a president who's doing so well. I mean, you got 3.2% growth in the economy. The Trump economy is hot. And the reason we're doing so well is as a consequence of the president's policies. And so at a time when my Democrat colleagues are focused on the next election and not solutions to the problems facing Americans, they can't attack the president's policies because people are doing well. So typically they roll next to identity politics, that based on what you look like, who you pray to, or who you love, you can't possibly support Republicans. But African Americans are doing better. Hispanics are doing better. Women are doing better. We are seeing a rising tide that is truly lifting all boats in this country. And so now we have this effort, not to argue with policies, not to typically go to the identity politics that functions as the organizing principle of today's Democratic Party. They have to delegitimize the guy that won, delegitimize the guy that people voted for, but they don't have the guts to do it directly, and so they're going after the Attorney General. Now, the gentleman from Georgia in his last remark said, we are hiding behind the rules. hiding behind the rules. These are federal laws that dictate what the Attorney General can and cannot do. We're not hiding behind the rules. We just like to follow them. By the way, it's not following the rules that got us in this trouble in the first place. When the Inspector General testified before us, he said it's the fundamental fact that during the investigations of Hillary Clinton and Donald Trump, you saw continuous examples of a one-off here, a violation of protocol there. The Inspector General said never before had he seen a circumstance where the very same team that was investigating Hillary Clinton would then go and investigate the other person that was involved in the 2016 presidential contest. About a month ago, in this committee, I laid out the stages of grief: denial, anger, bargaining, depression, and acceptance. And I think that folks watching at home can probably follow along and see where we're headed. First, my Democratic colleagues were in denial. When they saw that there was no collusion, after saying for 22 months that the president was an agent of the Russian government, after saying for 22 months that there was actual evidence of collusion, they were in denial when they saw the conclusion that there wasn't. Then there was anger. It had to be the Attorney General's fault. Mueller didn't make a decision on obstruction. Somebody had to. The Attorney General did. So they got mad at him. And we had this whole kerfluffle of anger. Well, now we know the third step: bargaining. Well, Mr. Attorney General, you've given us 92% of the Mueller report, but we have to bargain for the remaining 8% because that's really where we think the action is. Well, Mr. Attorney General, you spent 5 hours before the Senate Judiciary Committee. 3 of our presidential candidates got to question you. You offered to come before the House Judiciary Committee. You offered to come for an additional hour of questioning, but we have to bargain so that our staff lawyers can ask you questions. Now, I don't think it's a good sign that the next sign after bargaining is depression. So I feel for my Democrat colleagues, but after that we get to acceptance, and that's sure something that I'm looking forward to, because there are some really good ideas that my Democratic colleagues have once they kind of get to acceptance on the no Russia collusion thing. My friend, the gentleman from Rhode Island, has excellent ideas about how to change the way that consumers interface with big tech companies. My colleague from the state of New York is right, that if the First Step Act is the only Step Act, then that would be a bad thing. We need to do more on criminal justice reform. My colleague who's not with us from California, Mr. Swalwell, he's got great ideas to unlock potential cures with medical cannabis reform, but we're not doing any of those things. And by the way, I bet a bunch of my friends on the other side of the aisle low-key wish that their actual bills that would impact the lives of Americans would get heard instead of this garbage. The Obama administration ran an intel operation against the Trump campaign. Peter Strzok opened it up, the dossier kept it going, and now the Democrats need to get over it. I yield back.
Mr. Chairman, I move to strike the last word.
The gentleman from Florida. What purpose is the gentleman from Florida recognized? Move to seek recognition.
Move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you. Mr. Chairman, we're here today because we're witnessing the breakdown of the foundations of our nation's constitutional order. That's why we're here today. In 1974 in U.S. v. Nixon, the Supreme Court warned of moments just like this, when they said, once executive privilege is asserted, co-equal branches of the government are set on a collision course. The court went on to explain that such a collision, and I quote, places courts in the awkward position of evaluating the executive's claims of confidentiality and autonomy and pushes to the fore difficult questions of separation of power and checks and balances. These occasions for constitutional confrontation between the two branches are likely to be avoided whenever possible. Why are we on this collision course today? Because the Attorney General of the United States refused to provide information that is not privileged and is subject to the committee's subpoena. The committee issued a subpoena for information gathered by the special counsel. There's no privilege for this information. Executive privilege is not a cloak of secrecy that drapes across our nation's capital from the White House to the Justice Department. Yet last night, the Attorney General threatened a blanket privilege claim over materials that he knows are not privileged as retribution for the markup that we're holding right now. And this morning, he asked the president to do just that. It's striking how empty that gesture is. Chairman Nadler pointed this out last night. The Attorney General's request of a blanket privilege claim is empty of any credibility. It's empty of merit. It's empty of any legal or factual support. The Attorney General ordered his staff to send what he would define as a snitty letter last night. But those words were empty. Executive privilege exists to help the presidency function, to ensure that the president gets good advice and can make important decisions without interference from Congress. But that's not at stake here. We're asking for information that is no longer held in confidence among the president and his closest advisors. We're just asking for the truth that many already know but is being withheld from the public. Investigators know the truth. Private attorneys know the truth. The ranking member of this committee has seen it. The privilege no longer applies. What does apply is the American people's interest in the truth and the need for this committee to do its job, to protect our elections, to protect our national security, to hold the president accountable, and to draft legislation to ensure that no one, not the Attorney General, not the president, is above the law. Yet the Attorney General continues to mislead the American people. And after being caught in a lie in his testimony to Congress, he has now joined the president in his ongoing obstruction of the House. Congressional hearings and document requests are normal. They're normal. This committee holds an oversight hearing with the Attorney General every year. That is normal. But this collision course the President and Attorney General set us on is not normal. This collision is the definition of a constitutional crisis, and the breadth of this obstruction is beyond anything in our nation's history. The President has said that Mueller should not testify here. He has ordered without authority Don McGahn to refuse to testify here. He has ordered, in violation of the law, that the Treasury Secretary continue to hide his tax returns. He has blocked or delayed more than 30 requests from Congress. He has blocked testimony about the security clearances granted to his family members. He has blocked testimony about the humanitarian disaster caused by the Trump family separation policy at our southern border. This sweeping repudiation of Congress and congressional investigations is unprecedented, and it is unconstitutional. This is a government of, by, and for the people. The Attorney General of the United States is stonewalling the people. He is misleading the people. And he is actively working to suppress the truth. I don't understand, still, every time we have one of these hearings, how it is that none of my colleagues on the other side of the aisle seem at all concerned about Russia's attack on our democracy and their desire to do it again. And I close with this. The Mueller report finishes by reminding us that the protection of the criminal justice system from corrupt acts by any person, including the president, accords with the fundamental principle of our government that no person in this country is so high that he is above the law. We will continue to assert our oversight authority out of a duty to maintain the checks and balances that preserve the powers of separation and co-equal branches of government. A failure to do so would be a failure of our constitutional system of government. I yield back.
What purpose does the gentleman from Colorado seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Gentleman reserves a point of order. Is there an amendment?
Mr. Chairman. Mr. Chairman.
What purpose does the gentleman from Louisiana seek recognition?
Move to strike the last word.
The gentleman from...
I'll withdraw my amendment because it's not ready at this point.
I appreciate that. The Gentleman from Louisiana is recognized for 5 minutes.
Thank you, Mr. Chairman. We have heard some extraordinary claims this morning. I've been taking notes as my colleagues have commented on all of this. Congresswoman Sheila Jackson-Lee said the executive branch is, quote, taking a wrecking ball to the Constitution. And, Mr. Chairman, you said that the DOJ doesn't recognize Congress as a co-equal branch of government or acknowledge our oversight responsibility. Mr. Cohen said we're trampling upon Article 1. Anyone who looks at these facts objectively knows the truth is exactly the opposite. The Attorney General and the DOJ are objecting to this charade based upon the rule of law. They are trying to protect the integrity of our institutions. And Mr. Chairman, you said that the preliminary protective assertion of executive privilege this morning was a last-minute outburst. It's exactly the opposite of that. In fact, the letter that the DOJ sent to you this morning says, and I quote, regrettably, you, Mr. Chairman, have made this assertion necessary by your insistence upon scheduling a premature contempt vote. The letter goes on to say, you've terminated our ongoing negotiations and abandoned the accommodation process. And as we have repeatedly explained, the Attorney General could not comply with your subpoena in its current form without violating the law, court rules, and court orders, and without threatening the independence of the Department of Justice's prosecutorial functions. That's a quoting from the letter. The facts matter. The letter that the Attorney General sent to the President this morning that accompanies all this says, quote, the committee demands all of the special counsel's investigative files, which consist of, everybody listen, consist of millions of pages of classified and unclassified documents bearing upon more than 24 criminal cases and investigations, many of which are ongoing. These materials include law enforcement information, information about sensitive intelligence sources and methods, and grand jury information that the department is prohibited from disclosing by law. That's the letter the Attorney General sent to the President explaining all this. Look, we're attorneys on here. Most of us are attorneys on this committee. What does the law say? The courts have repeatedly affirmed the rules on all this. April 5th, just last month, the U.S. Court of Appeals for the D.C. Circuit ruled in McKeever versus Barr that district courts may disclose grand jury materials only where they have positive authority to do so, particularly through the exceptions to grand jury secrecy listed in Rule 6E. The Court of Appeals explained the vital interests, they said, that the rule of grand jury secrecy seeks to protect, including preserving the willingness and candor of witnesses called before the grand jury, not alerting the target of investigation who might otherwise flee or interfere with the grand jury, and preserving the rights of a suspect who might later be exonerated. These are critically important principles and traditions for us to uphold, and it is, again, the law. The chairman can file suit for access to the 6E material, but instead he blasts the Attorney General for not joining him in doing so. Why hasn't the chairman taken that step? I think I know why. Perhaps because he knows that his rationale for demanding the unredacted report is wholly insufficient. Look, this bears repeating. The chairman claims he needs the full unredacted report as part of the March 4th, 2019 investigation into the 81 individuals and organizations related in some way to President Trump. But let's make a couple of facts clear. The investigation, we don't even know if it's still ongoing. We haven't heard much about it lately. The lack of activity surrounding the investigations makes clear the majority here is not interested in pursuing this for any legitimate legislative purpose. This is about scoring political points. The chairman's public comments surrounding his need for the full report are almost exclusively focused on obstruction, but another important fact here, 99.9% of the obstruction volume is available right now for the chairman to view, but he hasn't done that. Only 6 lines and over 182 pages is redacted in the obstruction volume. This is not about seeking the truth, as we've heard this morning. It's about raw partisan politics. Our Democrat colleagues have weaponized our critical oversight responsibilities. And moving today to hold the AG in contempt is not only premature, unprecedented, and unwarranted, frankly, it is shameful. I think, we believe, the American people deserve better. I hope that they'll review the facts. I hope they'll look at all this correspondence. I hope they'll get beyond all this cloud of partisan politics and understand why we are taking the stand today that we are. I yield back.
For what purpose does the gentleman from Louisiana seek recognition?
Mr. Chairman, I would move to strike the last word.
Gentleman's recognized.
Mr. Chairman, I would just say that today is a very serious day. Today is a very regrettable day. Unfortunately, we have an administration that is choosing to have a temper tantrum that is designed to accomplish one thing. And that one thing is to never let the real facts of the Mueller report come to light, to never let the American people hear the whole story. The other side would have us congratulate them for telling 92% of the story. I wish when I was a child I could get away with telling 92% of the story to my mother. I would always tell the same good 92%. And I would leave all the bad deeds, lies, and crimes in the 8% that I don't tell. So you get no profile in courage. You don't get the Nobel Peace Prize, and you certainly don't get any award for honesty for giving out 92% of the whole story to the American people. But the real story of what we're doing today is that the president needed something to hang his hat on to prevent anyone who had anything to do with compiling the report from putting their hand on a Bible and taking an oath to tell the truth. And that's what we're going to ultimately have, is the president obstructing the testimony of everyone involved in the Mueller report, while he tells the national people and continues to promote and articulate and push and offer lies and fake news about the contents of the report without ever letting the American people see the whole truth and nothing but the truth. But I will tell the American people that are watching today that we have a solemn obligation to the Constitution. We have a solemn obligation to defend our democracy, to protect the homeland, to protect the right of the American citizens to have a free, open, fair election without the interference of any foreign countries, especially Russia. The bad news is that this will never be neat. This will never be clean. This will never be easy. This will never be convenient. This will be messy. But the one thing that the American people should know is that we're here at the right time to protect our democracy, and that the Democrats are not going to give up on our constitutional duty. We're not going to run or abandon this country or our citizens. We will never run. We will never retreat when we're fighting to save our country. And for the messiness, it will be that way sometimes. But the fight is necessary to protect this great country and to continue to move it towards being a more perfect union. There are too many people in this country's history that have given their life, blood, sweat, and tears to get us to be the great country that we are today. We will not let one administration, certainly not one person, we will not let one party be enablers to the criminal acts that we see over and over again. So just so that I can deal and speak in facts, so people won't just think that they're the Democrats go again. There have been 199 criminal acts that have come out of the investigation. There have been 34 individuals charged with crimes. There have been 3 companies charged with crimes. So let's just look at the orbit around this administration and see how fake this is. The former campaign manager in jail, former national security advisor in jail, the president's personal lawyer in jail. This is not a witch hunt. If it looks like a duck, walks like a duck, and quacks like a duck, it's a duck. And if it looks like obstruction, sounds like obstruction, smells like obstruction, it's obstruction. Thank you, Mr. Chairman. I yield back.
Mr. Chairman. Who seeks recognition? Gentlemen, for what purpose does the gentleman from Arizona seek recognition?
Move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman. Last week we saw an attempt to change the rules of this committee that defied the historical precedent of by applying only impeachment proceedings to Attorney General William Barr. And today we're zipping right along, and we know that my colleagues on the other side have the votes. They're gonna try to hold this Attorney General in contempt. But I'm interested to see the look on the judge's face when my colleagues from the other side present these facts. The court's going to say, "What'd you do? Were you in negotiations?" Well, we were, but we scuttled that because we refused to hear from the Attorney General because we changed the rules. You know, Judge, we changed the rules so the Attorney General didn't come in. He offered to let us view the less redacted report, but I didn't do that. I didn't even bother to go down there and look at that report. He offered to have staff members view the less redacted report with me. I said, no, we're not going to do that either. He permitted us to take notes on the less redacted report, and we rejected that as well. He asked us to continue to negotiate, see if we could work out our differences, but I rejected that as well. We attempted to compel him to respond in spite of federal law on Rule 6E, the grand jury material we've heard so much about today. We knew that there were some other witnesses that were important that might have shed light on this as well, but we didn't hold a hearing with DAG Rosenstein. We didn't hold a hearing on Mueller before we issued our contempt citation. We didn't seek closed-door, confidential, classified hearings with any of these individuals. In fact, Judge, you know what we did? We undercut our whole argument by making the argument to Mr. Barr, saying, hey, look, you know, Mr. Barr, why don't you just join us? Why don't you just join us in asking the court to authorize release of 6E material? What does that do? It says, quite frankly, that the folks that will be sitting there before a court propounding execution of a contempt citation, they're going to have the great privilege of saying, yeah, we put a sword of Damocles over William Barr. We created a Hobson choice. We said, guess what, Mr. Barr? You either get held in contempt or you violate federal law. Because that's just the way we do things in the Judiciary Committee these days. That's just the way it is. That is unprecedented, and it will hold this committee up to derision. And as my colleague, Mr. Johnson from Louisiana, said, there was a case that just came out last month which said, and this gets to my colleague from Georgia who said, you can't be misled, there are exceptions. That's right, and the court said you must fit within one of those exceptions before you can release Rule 6E material. But don't be misled, because nothing we're doing here today fits in to the Rule 6E exceptions. There's not an authorization under the 6E provisions right now. So there's going to be a problem, and I can't wait to see the look on the judge's face when these guys try to explain, well, we were trying to pigeonhole into something that's 6E. And then I'll just close in this area. When I hear that the wrecking ball is being taken to the Constitution, that it's being trampled upon, that we're a continued breakdown of constitutional order, these kind of arguments made over and over again, I can't help but say, if you think this administration, this president is so dangerous, why aren't you acting on the many resolutions for impeachment you've already introduced? I mean, Mr. Johnson was pretty clear. this whole thing is about impeachment. Well, take it to the American people. Take it, file your resolution. You've already filed them. Act on them. With that, my time is up. Thank you.
The gentleman, for what purpose is the gentleman from New York seek recognition?
I move to strike the last word.
Gentleman is recognized.
Let me first just say that I expect that when the court does hear this challenge, if it comes to that, I expect that she will rule in favor of the constitutional separation and checks and balances in our oversight function. I really don't understand the arguments that have been articulated by my colleagues. And as I understand it, there have been three different reasons that have been suggested for opposing our effort to simply uphold our Article I responsibility as a separate and co-equal branch of government. One, that this whole thing is a politically inspired witch hunt. Nonsense. Two, they want to all of a sudden protect the reputational interests of innocent Americans. Nonsense. Three, this blanket assertion of executive privilege. Nonsense. Let's take all three. First of all, 17 different intelligence agencies have concluded that Russia interfered with our election, attacked our democracy for the sole purpose of artificially placing someone at 1600 Pennsylvania Avenue. They were successful. And that's also what the Mueller report shows. This is not a politically inspired witch hunt. I'm confused. Every single person at the helm of this investigation is a Republican. The person who initiated the investigation, former FBI Director James Comey, Republican. The FBI Director who replaced him and presided over the investigation, Christopher Wray, Republican. The person who decided to appoint a special counsel to preside over the investigation and then monitored it at the helm of the Department of Justice, the Deputy Attorney General, Rod Rosenstein, Republican. The person who actually conducted the investigation, a war hero, a law enforcement professional, Bob Mueller, lifetime Republican. Who is the Attorney General going to investigate? The Republican Party? The notion that it's a politically inspired witch hunt is just one of 10,000 or more misrepresentations that have been spun out of 1600 Pennsylvania Avenue. It's a shame that you choose to adopt it and parrot it. Second thing, reputational interests? Really? Many of my colleagues on the other side of the aisle actually perpetrated a witch hunt as it relates to securing more than 800,000 documents from this very same Department of Justice without regard to the reputational interests of Americans who have served this country. You weren't concerned with the reputational interests of Hillary Clinton. In fact, the top Republican said that the sole objective was to undermine her, the former First Lady and Secretary of State. You weren't concerned with the reputational interests of Peter Strzok and Lisa Page. In fact, you embarrassed those two. They made mistakes, but you embarrassed those two. You weren't concerned with the reputational interests of Andy McCabe. So don't peddle that phony argument to us. This very same Department of Justice turned over 800,000 pages of documents, but they won't turn over a single page pursuant to a legitimately issued subpoena? And then you want to assert executive privilege. Are you kidding me? You can't assert executive privilege after the fact when the closest advisors to the president have already spoken to Team Mueller. Wait a second, let's try to go through this. White House counsel Don McCann talked to Mueller. There's no assertion of executive privilege. White House press secretary Sarah Huckabee Sanders talked to Mueller. No assertion of executive privilege. White House Communications Director Hope Hicks talked to Mueller. There was no assertion of executive privilege. It's a phony argument. The House is a separate and co-equal branch of government. We're not a wholly owned subsidiary of the Trump administration. We don't work for Donald Trump.
We work for the American people. We have a constitutional responsibility to serve as a check and balance on an out-of-control executive branch. The Attorney General is totally out of control. He will be held in contempt of Congress. I yield back.
What purpose does the gentleman from California seek recognition?
Strike the last word.
Gentleman is recognized.
Thank you. Mr. Chairman, this subpoena puts the Attorney General in legal catch-22. To comply with the subpoena, he must break the law. If he obeys the law, he must disobey the subpoena. Every person on this committee knows that the law forbids release of grand jury testimony. Congress is the law-making branch of government. If this committee feels it's so important to see the grand jury testimony, it can change the law. But it cannot order the highest-ranking law enforcement official in our country to break that law. You know, the American people can plainly see what's going on here. For 2.5 years, they have been force-fed a brazen and monstrous lie that the President of the United States is a traitor who's loyal to a foreign and hostile power. Robert Mueller was given extraordinary powers to investigate this. He appointed one of the most partisan and biased teams of investigators that has ever been appointed to substantiate these charges. They spent 22 months and $25 million in direct and component costs doing so. They employed some of the most abusive tactics, among them perjury traps and threatening family members, in order to turn up some shred of evidence to confirm this narrative. The Trump administration gave them every document they requested and even waived attorney-client privilege to make the president's personal attorney available for 30 hours of testimony. Though the president had the clear constitutional authority to terminate or interfere with the investigation, he did not. Well, after all that, they were forced to admit that there's not a shred of evidence to support this lie. We're now learning it was predicated on a fake dossier fabricated by the Clinton campaign and was used by the highest-ranking officials of the Department of Justice, the FBI, our intelligence agencies, and perhaps even the White House. First, to try to influence the outcome of our election, and after failing that, to undermine the duly elected President of the United States and tear this country apart. Now that lie's laid bare for all to see. The left's had now to think up a new lie, and think it up quick. Thus, in a heartbeat, the lie changed from collusion to obstruction. That even though the administration did nothing to interfere or impede the investigation, the president is guilty of obstruction just because he complained about the injustice of it all behind closed doors in words that amounted to no action whatsoever. They know this lie won't hold up under scrutiny either, so what to do? Well, the answer to that question is before us right now. Even though there was no legal requirement for the Mueller report to be released publicly, the Attorney General has released it with the sole exception of material he is legally forbidden to release, amounting to 92% of the document. He's offered the chairman and the ranking member of this committee the opportunity to review the additional redactions that can be reviewed in a classified setting, leaving only about 6 lines out of 182 pages. But instead of reviewing that information or changing the law to allow for its public release, they order the Attorney General to do what he legally cannot do and then charge there's a cover-up. They imply the smoking gun is now in that 6 lines and over 182 pages that cannot be legally shared, safe in the knowledge they'll never be called out on it. And they hope that there will be enough of a smokescreen to cover the perversion of our justice and intelligence agencies for political purposes under the Obama administration. One other point. Last week, the Democrats voted to change the rules of the committee to allow members to hide behind committee counsel to challenge the Attorney General. Mr. Chairman, we don't hire people to speak for us on the House floor, and we shouldn't hire people to speak for us in committee. Only members of the House should speak in House proceedings, and there's a reason for that. We're responsible and accountable for what we say in public forums. In this public forum, hired help is not. The only rightful exception is when we sit as a tribunal, an impeachment, because then we're sitting as a jury to hear evidence. Any exceptions from this makes a mockery of representative democracy based on the direct accountability that representatives of the people must have to those who elected them. I yield back.